and welcome to the Victorian Fitness Business Breakfast. Here we are this morning again with the legendary JT from Active Management and the superstar Mel Tempest from meltempest.com and your Ignite events. And this morning we're very excited to have two members of the Velocity team with us, Emma, Milne and Rose, do you get called Rosalind? Or
Rosalind, just call me Ros.
Ros, okay, Rosalie. So they're going to give us some insights on some of the legal knowledge we need to know, but I will let Mel do an intro and maybe give us any update on Victoria and how you're all going in Victoria now. Is it starting to pick up, Mel?
I feel like it is starting to pick up. Somebody asked me the same question last night, and I actually said, it almost feels like COVID never happened. The foot traffic's coming into the club, the members are working out, people are turning their memberships back on. Of course, there's still people, on suspensions. What we are noticing is there are still people who are cancelling, but they're cancelling because they've got employment in other states or they're moving back to Melbourne. I feel like COVID never happened. And, as soon as those restrictions are lifted, we can have more people into our group fitness. And of course, once we can go 24/7, I feel like it's just going to be a memory, and it's just going to be something that we talk about to our grandkids. So moving forward, nothing but positive. And I'm really happy with the way things are going in our club.
That's great to hear. So it's interesting you say it feels like, COVID's gone and you're moving on already. Is that sort of the mental space of a lot of people now? You're just moving on. You can get out. Is it sunny? Good weather?
Look, it's sunny. It's great weather. I still believe there will be a recovery process for the mental health of both the member and the teams in all clubs right throughout Victoria, if not right throughout Australia. And this is something that we're going to have to manage over the next, I still believe 3 to 5 years. We're still getting members coming in and talking, about their experiences through COVID, and we're having to manage how our staff answer those questions, because of course that's not why they signed up in the fitness industry, was to be counsellors. So I think the most important thing for club owners now is to ensure that their team have the resources and tools to be able to handle the members, because it just doesn't happen face to face. It's also a conversation that's happening a lot on the phone too. So somebody might ring up and say, look, my membership's on suspension. What are you doing in the club? And it's a conversation that you have. Yes, we've got sanitizer, class numbers are limited. Are you going 24/7? No, we're not allowed to at the moment, and this is what we need to do. So it's really having positive conversation with them, reinforcing that we're doing the right thing. But at the end of the day, it's up to the consumer whether they're going to come back in to the club or not. But we have to, just because I, as a club owner, see positivity and I feel that COVID never happened, that's me. That doesn't mean that that's how everybody else feels. There's still a lot of people out there that need to have their hand held, and that's okay.
Well, Mark gave us some great tips. JT, it's great to have you back this week. I know you checked out last week, and we did reference one of the stories you told us previously when we were chatting with Mark, the psychologist, for anyone who didn't see last week. And he gave us some really great first aid sort of tips for fitness professionals in-house. And any updates your end, JT? I know you had a look at that. And
I really enjoyed that, and I think it, it brought a few home truths back to us and the reality of the situation that we're actually in. I've just spent 2 days with 10 club owners from around Australia, and 4 of those club owners were in tears at different stages as we discussed, the last 9 months. And I think the reality is actually hitting some people now, like the adrenaline, like these ones are from New South Wales. So we've come out of lockdown. We've been going hard for now 3 months. And the reality is hitting that what has happened in the past, and the adrenaline now is coming down, and we're back into the grind of work per se, job keepers finishing for some of those owners. So there's lots of variables that are happening in their life, but the reality is the adrenals are coming back down. So whereas I've got one of those guys has got some clubs in Melbourne, and he had 400 leads month to date, 100 sales month to date, and this is a club that traditionally would probably sell 30 to 40 memberships a month. So,
Wow.
like, we understand like how screwed up people's minds and emotions might be, but on the flip side, they got 100 people walking in who are looking for an outlet and wanting to join a gym. And so our poor team members in some clubs are just now frantically busy.
Yeah.
Mm.
So it's almost like
No
any
recovery.
issues that they did have, we've just got to park them for a bit because we're dealing with all of these members that are coming in. And I think, and again, from Mel's perspective, it would be interesting to know, you know, as a club owner, are you focusing on acquisition or are you focusing on just getting your members back? And what message does it send to your members about getting them back if you're going hard on acquisition? There's so many little variables now as a business owner that you're now juggling on top of how people are feeling.
Yeah, just to answer that really quickly, it is about, you know, the member in your club because they've stood by you right throughout the last months. You've got to look after them. And you do that because that's a conscious thing anyway. But also at the back of your mind, you're saying there's a whole lot of people out there that want to join the gym. And my job when COVID wasn't on was to recruit new members anyway, because that's what we do anyway. We recruit and we change lives. So what you're trying to do is under your roof, you're trying to make sure that you're doing the right thing by your members, encouraging them to come back and give them everything that they need. But at the same time, you do need to acquire new members because that's what's going to keep your business afloat in the next 12 months because, you know, lifestyle changes for everybody. We can't assume that just because our members have walked through the door, they're all going to stay 2021. Lifestyle changes. So it's a bit of a juggling act. What's really interesting is, and talking to club owners is, as you said, they might only be signing up 30 or 40 people a month, and now they're getting 100 people that want to join. Are your sales teams really like ready to take on 100 inquiries coming through the door? And who's chasing them up? Like when they don't join is because the club owners are saying, I don't have any money in the bank to put more team members on the front desk, but I've got more people coming through the door. So it's really all hands on deck at the moment for all club owners. And I just think, again, we've got to give the club owners the right resources and tools and some tips on, okay, you can't put all your staff on the front desk because you can't afford it, but here's some other things that you can be doing so you don't lose those leads. Because people walk into a club because they want to join a gym. And when you're like my club and you have to get in your car and drive to it and they walk in, they want to join. So I do expect my team to sign them up. And so if they don't sign them up, I know that they've got to add them in, you know, to gym sales, and they've got to be on their doorstep every day until they can try and get them back as a member. So everyone's juggling at the moment. I think if the government had given us some sort of financial assistance, that financial assistance then could have helped us out with our staff behind the front desk.
That's a good point.
Makes sense. Yeah. I guess, and then it's still the juggle, like you said, mental health. So there's a lot to be doing all at once.
We're putting an enormous amount of pressure on our teams as club owners, and we say we aren't, but we are because we want them to sign up for sale. Yet at the same time, we've got to worry about that mental health issue also that we were talking about, not just the teams, but also our consumers.
Yeah. Well, let's shift into the gear of legal. And Mel, I'll let you do a proper introduction for our guests from Velocity.
Thank you. Well, first of all, both Ros and Emma have spoken at my Ignite Women's event. And I must admit, the feedback that came back when the ladies presented was overwhelming. And your videos are still one of our most popular downloads on our podcast. So first of all, congratulations, Emma and Ros, on that feedback. And so everybody, the ladies are the guns at Velocity Legal. I support them immensely against the boys. I think these two are absolutely dynamite. So Emma is a senior associate. Emma is a gun at property law, and she's a Pies fan. So for anybody that's watching right now, Emma is a Pies fan. And Ros is an associate who loves tax, but she's also a foodie at heart. So maybe Ros can share some amazing recipes with us later on in the show, or we can drop them in. But this morning, we're going to be talking about a couple of things that are on the lips of every club owner right throughout Australia. landlords, rent, JobKeeper, tax. Everybody's talking about it. So what I'm going to do is I'm going to hand over the show now to Emma and Ross, and they'll take us through a fantastic presentation.
Wonderful. Thanks, Mel. And thank you all for having us this morning. We're really excited to be a part of the Victorian Fitness Business Breakfast series. I'll just share my screen quickly. There we go. We can all see that.
Fantastic.
Wonderful. Thank you very much. So we'll start with our usual disclaimer. Just a quick note that this presentation is, and our comments this morning are general in nature. So the content shouldn't be taken as legal advice, and you shouldn't act solely off the back of the items raised. If anyone has any specific questions to their business after the presentation, please feel free to reach out to Rosalind or myself, and we'd be more than happy to arrange a chat. As Mel mentioned, I'm Emma and I'm a Senior Associate at Velocity in our property team. And I'm joined this morning by my colleague Ros, who is an associate in our tax team. We're here to discuss various schemes that have been implemented by the federal and state governments to assist small businesses get through and recover from the COVID-19 pandemic. Now, much of this is focused on the Victorian side, but the concepts are applicable throughout Australia. So if anyone's listening in from another state, by all means, reach out. I'd be happy to have a chat after. Business this year has been tough, especially for those in the fitness industry. There is light at the end of the tunnel with restrictions easing, gyms reopening and capacity growing. These schemes are available to assist businesses make it out the other side. Some are coming to an end, others are extended to March, and more are still yet to commence. If you're eligible, participate. Why not if it eases the financial burden and helps you get back on track? So as a quick overview of what we'll be working through today, we'll be working through the commercial rent relief scheme, including eligibility, the tie it has to the JobKeeper scheme, compliance with the regulations, relief available under the original regulations, and that is one of the items that's specific for Victoria, and also the extension that has extended the relief until the end of this year, and the possibility that it will be extended into 2021. Other considerations include long-term goals of the business, repayment triggers of the deferred rent, and the importance of documenting the agreement. Other changes that have occurred recently include processes under the Retail Leases Amendment Act. There's an inclusion now of a cooling off period and an early market review process that tenants can take advantage of. And finally, the government support, both the JobKeeper and the JobMaker. So firstly, with the, there we go. Two big changes to come out of 2020, and in fact, two concepts that were entirely foreign at the start of this year were the introduction of the JobKeeper and the commercial tenancy rent relief scheme. Rosalind will elaborate on JobKeeper eligibility and changes later in this presentation, but as a high-level overview, most commercial tenants whose turnover has reduced by 30% or more compared to last year should qualify. Now, this is important because the commercial tenancy rent relief scheme is directly tied to JobKeeper eligibility. In other words, if you haven't suffered a reduction in turnover of 30% or more, you are unlikely to be entitled to relief under the scheme. But that isn't to say that your landlord can't offer or can't agree to relief. Most people are familiar with Scott Morrison's announcement of the Commercial Tenancies Code of Conduct, that rent relief would be available for businesses while they're impacted by the pandemic, and landlords would be prohibited from evicting tenants for non-payment of rent during this period. It was then up to the states to legislate the code, and each has adopted a very different approach. In Victoria, the code is mostly mirrored in the COVID-19 Omnibus Emergency Measures Act and subsequent regulations. The relief is split into two parts, the first being from 29th of March 2020 to 29th of September, and the extension being the date that your request for relief under the new regulations was received by the landlord after 29th of September and until the end of this year. Interestingly, New South Wales, who have been moderately open for several months, have recently extended their rent relief until the end of this year. Western Australia, who eased restrictions and have been predominantly open since around June or July, have extended theirs until March. With legislation passed in Victoria, which enables the regulations to be enforced until 26th of April 2021, it's highly likely that Victoria will follow suit, although we don't recommend that tenants rely on an extension into the new year. The focus now, outside of reopening and bringing back members, should be the relief under the extended scheme if you haven't been able to obtain relief just yet. So what is rent relief? Eligible tenants who have suffered a reduction in turnover of 30% or more are entitled to rent relief, with at least 50% of whatever relief is offered being by way of waiver. That is not payable and not recoverable at a later date. The balance is to be deferred. The original regulations included numerous considerations that didn't strictly tie the reduction in relief to the reduction in turnover. And we've seen business owners offered relief that's significantly lower than the proportional impact that COVID has had on their business. I won't dwell on those considerations as the regulations expired in September. However, if you are having trouble getting rent relief outcome for the period from 29th of March, please reach out to me to discuss how we can help. And the earlier that you do so, the better. To be eligible for relief under the amended regulations, a tenant must forward a request in writing to their landlord, accompanied by various statements and documents in support. Importantly, relief under the amended regulations is only available from the date that the landlord receives a compliant request. The rent relief offered under the amended regulations is then tied directly to the tenant's reduction in turnover and removes much of the landlord's discretion, which should streamline the rent relief negotiation process. Once a compliant request is received, a tenant is also protected by the prohibitions on re-entry. Evictions and the drawdowns on security are also prohibited for failure to pay rent or outgoings through this period. But a tenant is required to continue to follow and comply with their lease otherwise. I reiterate that these protections only apply if the regulations do, and the regulations only apply if a compliant request is provided to a landlord in writing. In addition, a landlord must offer tenants an extension of their lease by the same period that any rent is deferred to recoup the lost time at the end. Tenants are not obliged to accept the extension and should consider the pros and cons of taking an extension of their lease, including the market review dates and how different review dates might impact the rental value. An independent real estate agent might be best placed to provide the guidance to that a tenant needs before accepting an extension. So you've negotiated relief, you're comfortable with the outcome, and you've got an email chain with the landlord and the agent acknowledging how much rent's to be waived and how much is deferred. Is this enough? We're seeing so many landlords and tenants reach this point and then balk at the idea of documenting the relief properly. We understand that 2020 is a difficult year and legal fees to prepare and negotiate a rent relief deed are not a number one priority. But what happens if you default on the repayments? What recourse does a landlord have to recover the amounts deferred? What processes should they follow? And are they prohibited from taking actions while the regulations apply? If you've accepted the extension, when's the end date? Does it push the renewal date to the new renewal process, which I'll elaborate on in a moment? What time frame and information does a landlord have to provide before the new renewal date, even if they've provided the information prior to the original renewal date? What about if you want to sell the business? Is the landlord entitled to a lump sum payment of the deferred rent as a precondition to consenting to the assignment of the lease? Are you entitled to an adjustment for the rental in your favour at settlement? Does the purchaser take over the debt, or do you have to reduce the purchase price to account for the amounts owed? If a landlord sells the premises, do they adjust the deferred rent at settlement, or are you required to pay rent to the new landlord and continue paying off the deferred rent to the old landlord periodically? I expect we'll see the impact of this over the next 12 to 24 months, but we recommend people consider these issues while negotiating rent so as to avoid these issues down the track. Deferred rent is accruing under both the original regulations and the extended regulations, and it's not repayable until at least 1st of January 2021 in Victoria. What does this mean for a fitness business? Those who have been closed for the majority of this year will have accrued upwards of 9 months' rent at a rate of 50%, which is expected to be repaid at some stage. The position under the regulations is that rent will be repaid from 1st of January in equal monthly instalments over the longer of 24 months and the remaining of the lease term. And this is consistent with Scott Morrison's announcement. For rent accruing at 50% over a period of 9 months and being deferred over 24 months, that is potentially an additional 18.75% of rent repayable each month by a tenant on top of their ordinary rent without rental increases. In a moment, I'll touch on the options available to tenants to request more permanent rent reductions to ease the longer term burden of the COVID-19 pandemic. But this repayment should be taken into consideration, especially when accepting the deferred rent, because it is going to increase the rental paid short term that, while the fitness businesses are potentially working at a reduced membership number. So it is considerations that need to be had. If you haven't already received relief, obtained advice as to the requirements to qualify for relief, or if you feel like you aren't getting anywhere, please contact your professional advisor who can assist. A delay in forwarding a request which complies with the requirements of the regulations could mean that you forfeit or significantly and detrimentally limit your entitlement to relief.
Emma, can I just ask a question?
Yeah.
You've just referred to repayments from January. I'm just wondering about people who may not have applied for relief yet. So they're in a situation now where they've realised they can't pay the rent.
Yes.
What is there a cutoff date at which you can apply? And then if you're applying now, does that date push out, or how does that work?
So in Victoria, we've got 2 regulations. The first one applied retrospectively from 29th of March. It wasn't actually released until the 1st of May. A request for relief that complied with the regulations through that period applied to the whole period. Under our amended regulations, and this differs amongst the states, but in Victoria, relief under the extension is only available from the date that a compliant request is received until the end of this year at this stage.
Okay, so if you're applying now, you've only got till December.
Correct. So the risk here is that tenants who have perhaps been trying to navigate this process themselves, who might not have ticked all of the boxes of the regulations, might actually fall outside of it, which is why we're urging people to have a look at what they've discussed so far with their landlord so that they can pull themselves into the regulations as soon as possible. The protections against evictions apply still retrospectively from the 29th of March, provided that that compliant request is received. So while a landlord's expected to negotiate relief from the date that that request is received, they can't actually take action for non-payment of rent for this whole period. So with that in mind, landlords are encouraged to continue to negotiate for this whole period, and in particular those who have leases and are fully aware that the premises is being used as a fitness business, because the fitness industry has been significantly impacted this year with the reopening pushed back much later than what other businesses have. Businesses have not all been able to pivot to that online model, and in particular fitness businesses in the franchise space who might actually prohibit that sort of pivoting. So they haven't been able to have any income for this time. So if a landlord really values the tenant for the long term, that regardless of the date that that request is received, I'd expect that they would continue negotiating for the whole period.
Just mentioning franchise, I had an understanding that the revenue of the franchise group was considered, and they were often not able to apply. Is that correct?
Yeah, so there's different ways, and it depends on how the business model and the franchise model is set up. We see some franchises who like to sign the lease directly with the landlord, and then they'll sublease to the franchisee. Now, in those circumstances, a franchisee is considered the tenant and the franchisor as the head tenant is considered landlord under the regulations. So a tenant can, or the franchisee can request relief from the franchisor, but the franchisor might not be entitled to relief because of they might fall outside of the scope of the JobKeeper, for example, which is one of the eligibility requirements, in which case a landlord's not required to offer relief. So you do have this sort of a friction point there where the franchisee is entitled to relief, but the franchisor is not getting it. So do they then have to come up with the money to pay the rent to the landlord? Or is it best to have a meeting with all three and see what can be arranged? Again, it really comes down to the value of a long-term tenant in a commercial premises and whether the landlord really does want them to be there on the other side of this pandemic. And I expect we're going to see some businesses that fall over, some businesses that do pivot to that online model or to that outside fitness model, for example, from a fitness business perspective, and they might not need the premises anymore, in which case it's vacant. So where there's then more vacant premises, it's a tenant's market, and then the landlord's probably going to have to concede some rent when they do get a new tenant in. So there's a lot of items that need to be considered beyond just what's in these regulations, because it's, you know, how is this going to impact us in the long term? And that's why the documentation of it's important, because it, from a legal perspective, we can discuss those additional items with you and what is your long-term plan and how did you pivot in this period, and do you need a premises that's the size that it is? In fact, are you growing? Are you going to need to go to another premises that's larger as well? So it's not just businesses that are shrinking in size. It could be that a new premises is much larger. It does, with the 4 square metre rule, it does allow many more people to be in there working out. So it could be that that's a better option for a tenant, because it means that they have the services for more of their members. And if their lease is coming to an end, it's an opportunity to look at that. Is this the right premises, and what can I do? Where can I move if I want?
Emma, I've just got the question. Do you think that commercial landlords will use this as an opportunity to move their tenants on?
We're seeing it a little bit. We're seeing some commercial landlords who are looking at their long-term plans, and whether they consider that they might want to, say, demolish and build a higher rise, and with that they'll have 3 or 4 tenants or more. And to do that, they need the premises to be vacant or a demolition clause in a lease, for example. So we are seeing some landlords that are, I suppose, offering only the minimum that's required, and that tenants are starting to get a bit worried that they're not going to be able to repay the amounts. And off the back of that, when it comes up for renewal, when a tenant's disheartened, they might think, well, I do want to relocate. And then the space is for the landlord to do with as they please. So it is something that's come up a little bit, but I think because of that vacancy, because of the potential reduction in demand, which again, it's something that we're not really going to see until next year or the year after with premises, but for a landlord at this stage, I think it's good to secure that tenant and really look after them if you can, because you know, it's the long-term goals that we're really after with business. And I think if they can work together, then obviously that's the best outcome.
I mean, the flip side of that is, you know, you spoke about businesses folding. If clubs do start to fold, that also means that there'll be property out there for current club owners to perhaps upgrade their facilities. So where they work in a 500 square metre property, you know, 1,000 square metre property comes up down the road, the business is folded, their members need somewhere to go. So there's also opportunity now for existing club owners and studio owners to upgrade into larger facilities. What's some advice that you would give to somebody now if they were looking at that opportunity?
So there's some changes that have come into play recently with the Retail Leases Act, and I'll touch on them in a moment. But one of the most important changes to come out of that is an early rent review process and a cooling off period. So whereas in the past a tenant would exercise their option to renew, after that they'd enter into the rent negotiation process. They might decide that it's too high, so they can get an independent valuer in, and then whatever the independent valuer determines is locked in because they've already exercised that extension of the lease. The process now allows a tenant to exercise the extension, but with a cooling off period of 14 days, or before exercising, dispute what the proposed market rent will be, and then go through that independent valuation process before committing to the new lease. Now, by doing that, they can then compare what their new rent will be to other premises. At that same time, they can be in discussions with the commercial agents in the vicinity, see what else is available. Start looking in the months leading up to your renewal so that you know what's out there. It's worth also knowing what sort of incentives might be available to you, whether there is a rent-free period, when it's available. Are they expecting you to sign a lease and move in straight away? Is there then going to be an overlap? Is it not available until too far into the end of your current lease so that there's going to be a significant closure period? All of those things need to be considered. But of course, if there is a premises that's just down the road, might be double in size, the rent will likely be more, but will it be double? It's going to be something that the agents can assist with, but that should be factored. And what can you do with that space? I mean, any large premises that doesn't have internal partitions, for example, yet, it's really just an open book of what you can do with the space. And knowing what we've been through this year, and knowing that we still have these restrictions on people per square metre, that can all be factored into these new spaces, as well as looking beyond COVID, beyond 2021, about how you can then increase the services and the number of members that you can have coming through your doors. So it's definitely something I think a lot of fitness business owners will be thinking about over the next couple of years.
Great. We'll keep moving along then.
Wonderful. Thanks, Mel. So as a summary of the rent relief that's available, it's so important that you know what your rights are under the regulations, and also know that the relief available is tied to the eligibility. So if you haven't already, get advice as to what you need to provide to your landlord so that you fall within the protections. Know your obligations under your lease. So where there's no documented relief, and where it might just be that email chain, if the regulations don't contemplate a process, for example, a default in repayment of the deferred rent, then how is it to be repaid? It will usually fall back into the usual process under your lease. Consider your long-term goals. Are you intending to expand? Are you intending to change your premises? Will selling the premises, or the landlord's intentions as well, will all have an impact on how you should deal with the relief. Don't concede and accept relief that's less than what you're entitled to. If you're intimidated by the process, engage an advocate to work on your behalf. The relief is in place for a reason, that being to assist businesses progress beyond the pandemic. There are processes, which I haven't gone into today, for you to escalate the matter, including an application to the Victorian Small Business Commission for mediation. and to then apply for binding orders if a landlord refuses to engage in the mediation process. You don't have to butt heads with a brick wall. The VSBC will be able to assist. Frustratingly, the original regulations and the amended regulations both have different processes and forms to escalate. This means that you might be required to lodge an application under each of the regulations to obtain relief through the VSBC. And again, strict compliance with the procedure is required, and we recommend obtaining advice if you're considering escalating the matter. The value in a simple phone call to an advocate can be significant. Don't delay. If you haven't already forwarded a compliant request, do it as soon as possible. And finally, document. So the other changes that have come into play in Victoria, and amongst all of the chaos of COVID and the extension of the rent relief regulations, was the hotly awaited Retail Leases Amendment Act. Now, the Act overhauls many processes and forces greater transparency from landlords when renewing a lease. It's important to note that the Retail Leases Act amendments only apply to retail leases. However, we expect that most fitness centres in Victoria will fall within the scope of the Act. One of the main changes is that the notice to renew process has changed. So previously, a landlord was required to provide notice to a tenant at least 6 months prior to the latest date that a tenant can renew a lease. If the period lapsed without notice, a lease with an option to renew would be extended to a date that was 6 months after the date that the notice was eventually provided. The notice requirements itself and the detail in there was pretty scant. Only after a tenant exercised their option to renew would a landlord provide their proposed market rent for the extended term. And while the market review mechanism is built into most leases whereby a tenant can dispute the proposal, the parties can engage an independent valuer to determine the rent moving forward, the tenant was already locked into the renewal and would also be locked into the market rent review, whether it increase or decrease. They didn't have an out. Now, the notice period is only 3 months, but the notice must also include the date that the option has to be renewed by a tenant, the landlord's proposed rent for the first 12 months, so a tenant can exercise their renewal with certainty. If they don't accept the proposed rent, they can exercise the market review process early. And that is, they don't have to wait until the lease is already renewed, can dispute the proposed rent before committing to the renewal, and wait until the outcome before making a decision on how to proceed. There are strict timeframes that must be followed, including that the notice to dispute the proposed rent must be provided within 28 days of receipt of the landlord's notice. I can't reiterate enough the importance of complying with timeframes in leases. And if you don't dispute the market rent proposed, you can still get out of the renewal if you provide notice to the landlord within 14 days of exercising the renewal that you've changed your mind. These processes give greater flexibility and control to tenants. And the reason for focusing on early rent review processes is that it's the tenant's best opportunity to negotiate a permanent rent reduction. Notably, a clause prohibiting a reduction in rent is prohibited in a retail lease, and an independent valuation can, in some circumstances, significantly reduce market rent. And we've seen some leases that reduce by 20, 30, 40% or more. It is a bit of a grey area where the old process under the Retail Leases Act and the new process overlap. That being that any leases that are due to expire within 3 months of the 29th of September this year, when the new the amendments came into place, they'll likely fall within the old 6 months notice process. And this is where the deferred rent lease extension could be beneficial to a tenant. Take this example. A tenant has a lease that expired on the 1st of December 2020 with one further term of 5 years. The latest date to renew is 3 months prior to the expiry, being 1st of September. Under the old process, the landlord was required to provide notice to the tenant on the 1st of March, being at least 6 months before the renewal date, that the latest date to renew would lapse on the 1st of September. The tenant exercised their option to renew before the pandemic took hold. By the end of the month, for this example's sake, we'll say that they exercised it on the 1st of March. By the end of the month, the unprecedented restrictions imposed by the state government have set in and the business is forced to close. The reduction in turnover is 100%. The landlord and the tenant successfully negotiate a 100% rent reduction for the period from 29th of March until 31st of December under both regulations. The landlord's required to offer an extension for the deferred period and the tenant accepts, taking the new end date to the 1st of August 2021. The latest date to renew, being 3 months prior to the expiry, is now the 1st of May. The tenant accepts the extension. It gives them an opportunity to recover from the pandemic and see the direction that their business takes once the state opens up. On or before 1st of February, as the amendments to the Retail Leases Act now apply, the landlord would be required to give a new notice which sets out their proposed rent for the further term from the 1st of August, the availability of a cooling off period, and also the availability of the early market review process. The tenant now has the option to assess the market, the rent, and their long-term plans at the premises before committing to the renewal. As at 1st of December 2020, they might not consider that there's sufficient information available to justify a reduction in rent. Subject to the advice from their independent agent or valuer, they might consider that it's more beneficial to wait and see how the market progresses when the pandemic passes and the government schemes and the incentives expire. The movement in the market and the potential increase or decrease in rent is something that a tenant should definitely discuss with an independent valuer or commercial agent as soon as possible. The difference in a market rental now or in 9 months could be significant. Unfortunately, the long-term impact of COVID on the commercial rental values is something that can only be guessed at this stage. Without a market rental review, or the option to surrender and negotiate a new lease, it can be difficult to force a rental decrease at other times. However, outside of all these fixed processes are, of course, commercial discussions. And that's, you can approach your landlord at any time to request a reduction in your rent. Your lease, including rent, can be varied at any time by agreement. This means that if you can pitch to your landlord the long-term benefits of a short-term rent reduction or the pros of having a long-term tenant at a reduced rent outweigh the cons of an empty premises, they might be willing to come to the table at any time. Before I move to the next slide, did you have any questions about those changes?
Don't have any questions, Emma, and it's obviously, it's very descriptive and it's very, very deep. All of this information that's required for the tenants and the landlords is actually quite overwhelming, I believe, for quite a few people. Now, what I do have to do is just jump a little bit to the right side there and just go in and introduce Rosalind, because we've got about 15 minutes left tops with our show. Now, I know that there's a lot of club owners out there that would have found all of that information really informative. So, guys, can you please get in touch with Emma, because the guys at Velocity, they're heavily focused on the fitness industry, so they're well equipped to help you out with anything in regards to property. But if you don't mind, Emma, if we can move across to Rosalind now on JobKeeper and JobMaker, because I also know that there's a lot of club owners out there now going, oh my God, JobKeeper's ending soon, I may not qualify. So best we arm them with some tools this morning before they head off at 9 o'clock.
Thanks, Mel. So these government subsidies on the slide may be of interest to business owners, and particularly in the fitness industry. But before I sort of run through them for the gym owners, no pun intended, I just want to take a step back and really echo Emma's comments earlier that this is a really, really tough year for businesses. And the schemes are here for a reason, the subsidies, and that is to give business owners that extra boost that they need to push through. So if you're eligible or if you have any questions at all, make sure you ask and make sure you reply. And as we know, like employment costs can be quite huge during these tough times. So why not get the support if you can? So just diving straight into the JobKeeper rules and the updates, conscious of time. Some of you may already be familiar with the earlier JobKeeper scheme, JobKeeper 1.0, which was introduced back in March 2020. And the original one actually expired on the 27th of September 2020. But the good news is from then, you may be aware that the government has put in an extension for 2 more quarters. So that's another 6 months. So what that means is JobKeeper 2.0 will continue until 3rd of January 2021. And then on the slide here, you'll see what we've named JobKeeper 3.0 will commence from 4th of January and run into 28th of March 2021. So a key thing to note with the new extension, if you like, is that new employees who may not have been eligible back in March can now potentially qualify, so long as they meet the requirements as at 1 July 2020. So I'll just give you a really quick examples. If you have casual employees, maybe a casual gym staff, if you like, who initially was employed for 11 months, so not 12 months to qualify, but they were back at 11 months in March. But then when you assess it at 1 July 2020, it has been over 12 months. Or if you have a full-time employee who didn't meet the criteria back in 1 March, maybe because they weren't employed then, it's a new hire that you hired and they meet the requirements at 1 July 2020, they may be eligible now. Or someone who was under 16 on 1 March and now is over 16 years of age. So long as you are eligible for the turnover test, which is the actual GST turnover decline compared to last year of generally 30%, you can apply for your employees who are now on the books as an eligible part-time or full-time or casual employee as at 1 July 2020. So what do you get under JobKeeper 2.0? The amount is different depending on whether you're part-time or full-time. So for full-time, which is based on the rules, is over 80 hours for the 4-week period before 1 July 2020. So that's a bit of a mouthful, but essentially it's about 20 hours per week. Then you are full-time. But if you're under that, you're part-time. So for full-time employees, as an employer, you get 1,200 per fortnight. And for part-time, you get 750. So this is lowered again from 4 January. So that's JobKeeper 3.0. So it drops to 1,000 a fortnight for full-time and 650 for fortnight for part-time. So all this information is on the ATO's website, and we have some information on our website as well. So don't worry if you can't get all those numbers floating around town. So that's all good. So there is a note just to be aware of in the Treasury's fact sheet and the legislation where there may be circumstances where somebody's hours are not usual at the test time of 1 July. Maybe they were on leave, maybe there was something else. There are some flexibilities there. So not everyone's situation is, exactly the same. So just be aware of those, and I'm happy to discuss anything offline if there are sort of specific scenarios. And finally, as Emma mentioned earlier, JobKeeper is highly relevant if you're considering eligibility for relief. So another reason just to make sure you look into these schemes and check if you qualify. So to sum up, I know I ran through that really quickly. Just conscious that we want to get that in before 9 o'clock. To sum up, the key takeaway is that JobKeeper has been extended to 28th March 2021. The payment rates are slightly different from 4th of January. Yes, 4th of January 2021. The key date for assessing eligibility is now 1 July 2020 rather than 1 March. So people who didn't qualify last round back in March may potentially qualify now. And yeah, if you're not sure about any of these criterias, make sure you pick up the phone, give your accountant, bookkeeper or lawyer a call. And that's what we're here for, to be honest. So just make sure that you apply. What you can do is you can apply via the ATO's MyGov or the ATO business portal. So moving on to the job maker hiring credit, the question some people might ask is, what happens if I don't qualify for JobKeeper 2.0? So what if businesses picking up now from the reopening, potentially the required 30% reduction in turnover compared to last year might not be met. So what do you do then? Well, this is a good segue to what they call the job maker hiring credit. It's interesting, there's all these different phrases running around, but there's a job keeper and now we've got the job maker. So this might be relevant and helpful if you might have needed to let staff go during the last few months, or casual staff may have left, but following reopening, and I thought it was really good points that Justin and Mel was saying, you need the sales staff, you've got traffic through the door, you need someone behind that front desk to follow up. So you want to get the staff numbers back up again. And so the job maker might give you that extra boost of cash flow to hire new staff, particularly what they're targeting at is younger staff. So the job maker was introduced as part of the 2021 budget. And basically from 7th of October 2020, and before I move on, just want to note, this has been legislated, so it is in place now. So basically from 7th of October 2020, eligible employers will be able to claim, so that's $200 a week for each employee that they hire aged between 16 to 29, or $100 a week for those between 30 to 35 years old. Again, these numbers are on ATO's website or our website. So unfortunately, if you're if the employee's under 16 or the new hires over 35, they won't qualify, and they also wouldn't qualify if they work less than 20 hours within the test period. So it's about you're looking at back date, so about the 3 months period before February, which I'll come to in a moment, because that's where you register. So how you register is that it will open on the 7th of December 2020, and you can start claiming the first payment on 1 February 2021. And it's sort of backdated, so you claim quarters in arrears is what they call it. So for October, November, December, in January. And so basically it's for the 12 months period after 7th of October from the start date. And that could give you a total of $10,400 if you kind of work through that up to that amount. Unfortunately, businesses who are already receiving JobKeeper, which is the one I was speaking about earlier, they're not eligible for the job maker. That's quite just really need to be aware of, and you need to check if you're already receiving JobKeeper for any one of your employees. So then unfortunately you can't also claim the job maker. And I suspect that's probably the reason the government has done this. Might be political. They just want to make sure that people can just get one wage subsidy. And yes, so finally, I just want to reiterate that if there are any questions about whether you qualify for any of these support and subsidies, make sure you reach out and apply if you can.
Sorry, Mel, you go.
I've just got a really quick comment. Yeah. $200 for the younger generation and $100 for the older generation. I would have thought to get the older generation back into the workforce that they would have flipped the reimbursement around and given more money for us to hire older people as opposed to the younger people.
Exactly, that's what you would have thought, but not sure. It's probably a political reason they've done that. So sounds like, oh, it's for young job seekers. And another thing I missed is that the person also has to be receiving a job seeker payment and other sort of youth allowances and and other
Okay.
I
parenting
think
apps.
youth unemployment's incredibly high at the moment. It's that age group, isn't it? And that's why they've targeted.
Yeah, having said that, I've read a few articles and surveys where they've sort of checked, and a lot of young people were pushed out sort of first from the COVID-19 when people were letting people go. So there has been a few reports in that space for young people as well.
Ros, just a quick question and I guess clarification. While staff have been on JobKeeper, they still accrue their holidays, don't they?
I believe so, yes.
So this is a really interesting challenge that many club owners are facing right about now.
Yep.
And that is
Christmas.
all of these people that they've had on JobKeeper doing the right thing by them to help them get a wage during lockdown. And all of a sudden now they've decided that now's the time to go on holidays between the 15th of December and the 15th of January. And so lots of employers are seeing these people that have been on JobKeeper now wanting to take time off because they're back at work. They're exhausted. I've been back at work 2 weeks. I'm tired. I need a holiday.
Back at work.
Oh my goodness.
Are we right in saying that?
Yeah, I believe so, Justin. And that's really interesting observation you've made there. And if I was the business owner and I've, looked after these and not, let anyone go and maintain them on the books and looked after them, and suddenly they're taking a break, like that is quite a challenge, especially now going towards Christmas. But yeah, in answering your question, I believe leave does accrue. And there were some, interestingly, I was reading another article that there's some sort of controversial issues where people were on sort of unpaid paternity leave, but they were also, because they're on the books, you can still get they weren't expecting this $1,200 fortnight, and they're on sort of unpaid parental, but they're getting these money in that they wouldn't, sort of like a windfall, if you like, that they wouldn't ordinarily expect. So there are a few things coming out of JobKeeper that when you have like a flat rate or like a scheme for this, there are sort of other scenarios that might not be accounted for.
Get advice. That's my message to owners. Get advice.
Yeah. There wouldn't legally, I'm guessing there's not a lot that business owners could do. Would that?
Nothing. There's nothing.
Wow. Sorry, I'm shocked.
Away from COVID-19, yes.
Wow.
Rosalind, can I just ask you a question? Do you think that JobMaker is going to get more people employed? Do you think businesses are going to go out there and start employing staff based on, a $200 or $100 windfall? Because it's not a lot of money. I mean, in my industry, we haven't had any financial assistance whatsoever, so I don't get excited over those dollars. Do you think it's going to help?
That's a really good question, Mel. And I know there are like different views out there. People were saying it's only going to be 10% of genuine sort of new openings, or people might just replace existing staff, although there are tests in place with headcounts and things to make sure you don't do that. But it is, I do acknowledge it's not much, but all up it's 10,400 if you do hire someone for 12 months. So it's better than nothing, but I do acknowledge that it's not going to be a huge, significant, game changer for all business owners. But it is, if you're eligible, why not apply?
Ros, can I ask, with the JobMaker, can it be a part-time or a contractor? Like, can you just put that towards a bookkeeper or something, or does it have to be a full-time employee?
It can be part-time and full-time, but there is that distinguishment between an employee, a part-time employee, or just employees in general versus a contractor. So that's another presentation, I think, all on its own. But yeah, just business owners, what you can do is just be aware of that difference.
So there is a loophole to be able to make it worthwhile. Ideally, you could put it towards getting a good bookkeeper if you didn't have one or something like that. But do they have to be put on? Okay, so that's another whole conversation. I get it. So there might be a loophole.
I would have loved to have seen here in Victoria, because Dan Andrews was so adamant that, you know, if you wanted to open your club 24/7, that you had to have a COVID marshal. I would have loved to have heard him come out and say, yeah, you can open your clubs 24/7 with the COVID marshal, and we'll actually open up and allow you to put your COVID marshals on JobKeeper. So that we could have done that, would have been so much better than saying to us, here's your business, you can have 150 people in it now, but hey, guess what? You want to go 24/7, you've got to pay somebody. We can't be doing that because we can't afford to be doing that. So now we're pushing 150 people into a shorter time period when it would have been better to get the foot traffic in over a 24/7 period as opposed to 12 hours. And that would obviously, you know, decrease the risk of COVID. So what I would have liked to have seen is Dan Andrews come out and say, the fitness industry, we're going to open up, you know, JobKeeper for the COVID marshals. But of course that didn't happen. And many clubs aren't doing 24/7 at the moment.
Yeah, exactly.
Would have been good. Edwina, Justin, have you got any questions for Emma or Rosalind before they head off?
No, I got none. That was fascinating. And yeah, I think I would go back to the very first slide if you've enjoyed today's presentation, which was the disclaimer, and it said something like, if you've got questions, contact Emma or Ros as quickly as possible, because I really do think, you know, we're not in the business of understanding leases. We're not in the business of understanding the intricacies of employment law. That's what Velocity Legal do. So I just don't understand why a club owner, maybe Mel, as a current club owner, you can answer this, but I don't understand why you would try to put yourself through hell trying to work it all out when you can just go to experts and pay them to do it for you. Sorry about those birds. They agree with me.
Yeah, totally agree with Justin. Don't try and do something that you're not qualified to do. You entered the industry to change lives and to keep people healthy. You didn't enter the industry to become lawyers. So, you know what they say, delegate. So delegate to Emma and Ros. They're absolute guns at what they do when it comes to property and tax. Their details are there on the screen for everybody. So I strongly suggest that you shoot that right now, grab their web address. And just before we head off, if Emma, just really short in closing, if you could just tell everybody about the merger that Velocity has done in the last couple of months. I know Scott would appreciate that greatly.
Thanks, Mel. And we're so excited to announce it, that we have merged with Atticus Lawyers and Advisors. What they bring to our team is the litigation and insolvency expertise. So again, it's so important that people get advice early on. And if you are struggling with finances at the moment and not sure what the future looks like for you, reach out to us and I'll get you to contact our team from Atticus, because they'll be able to help you get some processes in place to avoid insolvency, and then we can focus on the future and growth again. So it's a really exciting service that really complements the other services that we have on offer here. So thanks for raising it, Mel. It's very exciting times for us.
You're very welcome. So that's our show today, everybody. If you missed first and second week's episode, all you need to do is jump across to the Active Management platform and, of course, the Edwina's platform, and you'll see a replay of those episodes. Next week, Justin, is your guest, if you'd like to tell everybody, and then we'll close off.
Yeah, next week we've got Sam Mudamar, who's an expert in PR and social media. And I think what was very much apparent in Victoria was how the fitness industry was lambasted by the media. And so she's going to come on and try to help us put a spin on how good a things we actually, is that even a word, as good a thing?
It works.
Does it work?
I would say so.
My English sucks. How good we can put a spin on things around our industry so that the media pick up on the good stories and not the bad stories.
Fantastic.
Awesome.
All right, thank you everybody for this morning. Thank you again, Edwina, for hosting the show and organising everything over the last couple of weeks. I'll sign off now and I'll talk to you all real later.
Thanks, Emma. Thanks, Ros. Ciao.
Thanks for having us.
See you guys.
You're welcome.
Justin.